A jury awards you 50 pounds in damages. You won. The other guy was late, your business suffered, and 12 people agreed you deserved to be paid. Then the appeals court throws the whole thing out. Not because you were wrong about the breach, he was definitely late, but because the carrier didn't know your mill was sitting completely idle while he dragged his feet. That's Hadley versus Baxendale, decided in 1854, and it's the case that still controls what you can recover when someone breaks a contract with you. And that decision changed everything. Hadley ran a flour mill in Gloucester. The crankshaft on his steam engine snapped, and without that shaft, the entire mill stopped. To get a replacement made correctly, the manufacturer in Greenwich needed the broken shaft as a physical template. So Hadley hired Baxendale, a carrier operating under the firm name Pickford and Company, to transport the broken shaft from Gloucester to Greenwich. The price was £2 and 4 shillings. Baxendale had a specific delivery deadline, but he missed it, which meant the mill stayed shut for extra days, and Hadley lost profits during that downtime. I still think about this all the time. Baxendale had no idea the mill was completely offline. From his perspective, he was just moving a broken machine part. For all he knew, Hadley had a spare shaft sitting in a back room, or the mill was already shut down for a different reason, or this was routine maintenance on an otherwise running operation. He had zero information suggesting that every single day of delay was eating directly into Hadley's profits. The jury at trial sided with Hadley and awarded £50, but Baxendale appealed to the Court of Exchequer, arguing he couldn't be on the hook for losses he had no way of anticipating when he agreed to make the delivery. The Court of Exchequer reversed the jury, and Baron Alderson wrote the opinion, and what he wrote became one of the most cited rules in contract law history. By 1994, Supreme Courts in 43 U.S. states had cited it favorably, and it's codified in the Restatement Second of Contracts at Section 351. The rule Alderson produced goes like this. When someone breaches a contract, they owe damages for losses that were reasonably foreseeable at the time the contract was made. Not at the time of the breach, not in hindsight, but when both parties shook hands and agreed to the deal. There are two categories. First, general damages, losses that flow naturally from this type of breach in the ordinary course of things, stuff any reasonable person in the breaching party's shoes would anticipate. Second, special or consequential damages, losses tied to the non-breaching party's particular circumstances, which are only recoverable if those special circumstances were communicated to the breaching party before the contract was formed. If you're struggling, this might be why. That second branch is the one that trips people up on the bar. The objective branch asks what would normally happen when this kind of breach occurs, and the subjective branch asks what this specific defendant knew because the plaintiff told them. If you had unusual exposure and you kept it to yourself, you're locked out of recovering for it, so you only get what a typical plaintiff in your position would recover. I've been watching how information moves between parties in a deal or doesn't move. With cold outreach, one thing that always comes up is how much context you give the other side before you ask them to commit to anything. If you want someone to price a job correctly, they need to understand what's at stake. Baxendale never knew the stakes before agreeing to take the job, and that's what cost Hadley in court because he couldn't sue his way out of a conversation he never had. I learned this running my own business. Baron Alderson's reasoning was grounded in how contracts work as voluntary exchanges. When Baxendale agreed to carry that crankshaft for £2 and 4 shillings, he was pricing that job based on what he understood the job to be. If Hadley had said, listen, our entire mill is down and we're losing money every day until this shaft arrives, Baxendale could have charged a higher price, walked away, or required a specific damages clause in the agreement. But by staying quiet, Hadley prevented Baxendale from making an informed decision about the risk he was taking on, and the court called that unfair. And it is. Alderson also pointed out that in what he called the great multitude of cases involving millers shipping broken shafts, plenty of those situations wouldn't produce a total work stoppage. Maybe the miller had a spare. Maybe the mill had multiple engines. Maybe the timing didn't matter much. The fact that Hadley specifically had this particular exposure didn't make that exposure generally foreseeable. General foreseeability asks what would ordinarily follow from this type of breach. It doesn't ask about the worst-case scenario that only this one plaintiff happened to be in. Let me show you what I mean. Fuller and Purdue noted in 1936 that the foreseeability test is a framework, not a bright line rule, but the core incentive structure has held. The plaintiff is the one who knows their own special circumstances, and the cost to Hadley of disclosing the mill shutdown was essentially zero, while the benefit of that disclosure, putting Baxendale on actual notice, was enormous. The rule creates an incentive for the party with private information about their vulnerability to share it before the contract is signed, which is exactly when that disclosure does the most good. Let me walk you through a hypo so you can see this rule work in real time. Sophia runs a boutique wedding photography business. She hires PrintFast to print 200 custom wedding albums for an annual bridal expo. She tells PrintFast the specific date the expo opens. PrintFast promises delivery 2 days before. They deliver 5 days late, 3 days after the expo already ended. Sophia lost a $500 non-refundable booth fee, missed an estimated $15,000 in expo sales, and also lost a completely separate hotel chain deal worth $50,000 over 3 years because the hotel wanted to see her physical album samples that same week. Start with the $500 booth fee. Sophia told PrintFast the expo date, so a printer who knows albums are due before a specific expo can foresee that missing that date wastes the booth fee. And that's recoverable under the second branch because PrintFast had the special circumstance communicated to them. The $15,000 in estimated lost expo sales is also recoverable under the same logic. Sophia told them the albums were for the expo, and a printer in that position knows promotional materials exist to generate sales. Lost sales at the event are the obvious reason someone orders materials for a trade show, which means PrintFast should have contemplated this. Okay, now flip it on its head. The $50,000 hotel chain deal is where Hadley shuts Sophia down completely. That opportunity was separate from the expo. It was coincidental timing. PrintFast had no idea Sophia was pitching a hotel chain, no reason to know physical albums needed to be available that specific week for that pitch, and Sophia never told them. Under the first branch, a missed hotel partnership deal doesn't naturally flow from a late printing job. Under the second branch, Sophia never communicated those special circumstances, which means PrintFast couldn't have priced that risk or declined the job to avoid it. The $50,000 isn't recoverable. If you're doing this, you're leaving money on the table. On an exam, you trigger this analysis when the plaintiff's claimed loss exceeds what the breach directly caused. A vendor delivers software late, and the buyer loses a major client. A shipper delays goods, and the buyer misses a market window. The delayed delivery caused the loss, not a separate chain of events. A contractor finishes late, costing the owner rental income that never came in. Every time you see that pattern, run the Hadley analysis. Was this loss foreseeable to the breaching party when they signed? If yes, general damages. But if it required special circumstances the plaintiff never disclosed, it's not recoverable. The result in the original case flips entirely if Hadley had opened his mouth. If Hadley had told Baxendale before they contracted, "Our whole mill is completely down, we lose money every day until this shaft gets there, this delivery has to be on time," those lost profits fall squarely in the second branch because the breaching party knew. The special circumstances were communicated, which means Baxendale would have been on the hook. Same facts, different conversation before the deal closed, and a completely different damages outcome. That one insight changed my whole approach. This is also why consequential damages clauses exist in modern commercial contracts, big software agreements, logistics contracts, service deals. They almost always have a provision that specifically excludes consequential damages or caps liability at the contract price, and those clauses are a direct response to Hadley. Sophisticated parties don't want to litigate foreseeability after a breach, so they negotiate the risk allocation upfront, in writing. That's the rule working exactly as intended, pushing risk conversations to the contracting moment, not to the courthouse. The answer is way simpler than you think. If you have unusual exposure, say so before you sign. If you're the service provider, ask what's writing on your delivery, because that conversation is what the law is designed to force you to have. And if you're studying for the bar, every time you see consequential damages claimed after a breach, check whether those damages were foreseeable at contract formation and whether any special circumstances were actually disclosed. That's your entire Hadley analysis in one sentence. If you ever need to find someone or run a background check, go to Scraper City. If you want to grow your law firm using outbound techniques where legally allowed, check out Galadon Gold. And to automatically grow on Twitter and X, use Tweetloft. The next video is coming up now.